Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on time. Time for a girl on time. Time for a
Where's the joint I just rolled? Ugh. God, timing is fucking impeccable around here. Oh, it's on the floor. I found it. It's on the floor. I don't know if you can hear the motorcycle pulling into the driveway. That means my roommate is home. Please get your votes in the chat. Would you like to go on a dating adventure with me where we can decide who I should date and rate my outfits? I mean, we could rate my boobs for the day, you know, all those different kinds of things as I try and take on the dating world. Would you guys be interested in seeing that or no? Please get your votes in the chat. You can tell me straight up, but it'll hurt my feelings, probably. I'm just joking. I hope that everybody is doing well today. Christy's in. Christy's like, fuck yeah. I want to see it. I love that. You know, I just feel like I deserve a man who will text me every day. Does that seem like too much to ask? Actually, let's go over some of these. Let's go over some of these requirements. I like to be talked to. Funny. I like attention. Once in a while, a gift. What else? Oh, sex. That's never a problem for me. Oh, Carol is gonna live vicariously through me. I love it. Hi, Beverly. Oh, Julie, thank you. And you know what? That is right. Oh, Christy, thank you. Treats me right. That's right. You know, there is a lot of, MC, you're making me laugh. There is a lot of, I better start dating women. I tried that, Bill. Didn't work so great. I've lost my, I lost my train of thought because I'm neurospicy, and it's too much for a lot of people. It is. It really is. I've had people ask me before, like, my God, why are you single? I'm like, fucking try dating me, and then we'll talk about it. Everyone shuts the fuck up pretty quick after I say that, huh? Anyways, but I think we could have some fun. We could talk to some people via my Tinder. We could, or whatever app we find. We could put me on whatever apps we want. We could even crowdsource my outfit. You know what I mean? Like, do you want to see me in a specific outfit? Well, fucking get on Amazon and send it to me. I just found this red shirt. I love it. Certainly makes my boobs look 11 out of 10, as Courtney would say. Anyways, so listen, Bill, I provide sex, sandwiches, and a few other S words. Spontaneity. And a few others. But I'm a personal chef. That's the beautiful thing about it. I'm a personal chef and I like to cook naked. That's been a problem for a few of my clients. But some people really like it. I'm not actually kidding about going on some dates and making, putting myself out there. I think that's what we have to say. Yeah, my clients. My clients. I'm a personal chef. I actually am a pretty good chef. And I do a lot of personal things. Anyways, we're back at it again. We're back at it again. You know what the biggest problem for me is? I smoke too much weed. I drink too much pop. And I talk too much. As far as I can figure out, that's the issue. But, speaking of that, let's smoke this joint, watch the court. So, as a setup, if you're watching this, how come the can was orange and the drink was red? Bill, great questions. Well, remember that I've talked about this before where I've said, oh, I've never drank Red Bull in my life as I was drinking this, not realizing that it is a Red Bull. And I think I like the taurine. We've talked about this before. There's something in there. I sniffed it yesterday and I was like, oh, I like that. It's a chemical smell that I really like. I'm going with taurine or guanfacine, one of the two. Anyways. Hair doesn't look as good in this shot, but my boobs look better. Oh my god. Okay, so we take some, we leave some. My hair looks like shit, but my boobs look better. I like it. I'm willing to accept that trade-off. Okay, so we have to go back to our downloads. This was a 5-hour docket that we got through most of the other day. Oh, by the way, I did a lot of recording of court today. Bill. Always making me laugh. But we're like here. Okay, so first of all, I just want you guys to remember where we left off. We left off, and look, the lady and her lawyer are talking here for quite a while. I'm young, not ready to date. I mean, I have a 16-year-old kid. I'm not that young. I'm like, well, I don't even want to say what I'm almost, but whatever. Oh, Christy, maybe we should be in a relationship then. If you don't mind listening to me talk. No, seriously, I do. I talk a lot. I'm too much for most people. I really am. I really am. Like, a lot of guys will be like, oh, I want to date you. We should date. Really, you can't handle it. You can't. It's too much. It takes a special kind of man. Anyways, Judge, can we get back to it? Nothing to it but to do it. As Katina would say. There's a special
Whether or not it had
Katina.
jurisdiction. Hear this.
Okay, here we go. Here we go now. Also, I will try and follow this case as we go through. I don't know if they want hit it and quit it. I don't think they want hit it and quit it. QW, I think you mean we. But who's QW? Should I be talking to them? Oh, Reed, you're nodding. Judge, this is awkward. This is why I lose viewers every day. Oh, you guys, I made a whole list of all the food I have in the house that I can make. Look at that list. That's so many items. Do you see that? That's so many items. Barbecue chicken salad, chicken burgers, need buns, tacos, ground beef, burgers, need buns, pizza, frozen, butternut squash pasta, sandwiches with turkey, burrito bowls. Can I get through all of these before the judge comes in? Taco bake, pancakes, quesadillas, quiche, ham and cheese, breakfast biscuits, spaghetti, smoothies, apples and peanut butter, avocado toast, egg salad, ramen with eggs, mushroom orzo pasta, oatmeal with raspberries and pecans, banana bread, oatmeal cookies. I wrote breakfast wraps twice. Beans and rice, hash browns, fried rice, stuffing gravy, mashed potatoes, huevos rancheros, green beans with garlic, chicken nuggets, soup mix, tomato soup and grilled cheese, egg bites, and shrimp pasta. Does that interest anybody? Those are literally everything I have the ingredients to make right now. Ooh, strawberry banana smoothies. Yeah, I have raspberries. Christy, would you accept raspberries? Oh, we know what's gonna happen. If I hit fast forward, they will fucking just be already talking. Oh, apparently not. Oh, good. Because it was like another 6 minutes. Okay, there we go.
And only dealing with the jurisdictional issues. So if you want to make any sort of argument, I'll be glad to entertain that. So we'll let you, Mr. Walker, if you wish to.
I would like to, Your Honor.
Also, on my
May I
baking
proceed?
list. Wait, before you start.
Yes.
Sorry.
So,
Rose. On my baking list, so I had to write, like, some of those things I have to bake. And so my baking list includes banana bread, which I didn't even put on the other side. Okay, so add banana bread. We've got chocolate chip cookies already portioned out in the fridge. But that's for my daughter's business. I've become a baker for her to sell cookies at school. I do it every week now. She's like, she puts in the order and then I make the cookies and she takes them to school and sells them. And we did talk about, carrot cake. I can make carrot cake, Carol. We did talk about how much it costs. So she's at least making that back. But anyways, oatmeal cookies, those are for me. I want to make some that are like salty. I like salty oatmeal cookies. And then I'm going to make the hamburger buns that we're out of, and I'm going to make the baking powder biscuits. So, okay, now that we are up to date on my, well, it's a menu for me, but it's a menu for the house because I'm not about to go grocery shopping again because I don't have any money. So this is all we got for 2 weeks. We have to live off of all this food. Ooh, it's not salty. Well, I might check it out anyway, Cellulite Yoga Pants. Okay. Are we ready? I think we're ready. We're ready. Let's go.
I'd like to start by apologizing to the court. I think I let the pressure of bad Nashville traffic in our early morning get to me. And I realized when I first came up to the podium, the court posed a question and then repeatedly asked me if I understood the question that it was asking me. And although I said yes, I reflected upon it and realized that I was incorrect. I believe what the court was asking me was there anything that could prevent this court from determining whether or not it had jurisdiction to hear this case? And to be sure, it can. As the California case can also decide whether or not it has jurisdiction. And then I proceeded to argue Article 4 of the Constitution and the first to file doctrine, which I think the court was very politely trying to indicate was not what we're figuring out at this point.
Let me reassure you of one thing, Mr. Walker. I have stood in your shoes for longer than perhaps you've even been alive. Practicing law for 37 years and argued before judges on a regular basis. I don't take personal.
37 years is exactly how old I am. We don't gatekeep around here about my age. Could we find me a lawyer, do you think? Do you think I'm too much for a lawyer? Could we work on that or what? What do you guys think? Is there like lawyers looking for love? LLL.com. Lawyers looking for ludicrous love. There we go.
the fact that you may have disagreed. I don't take personally that you disagree with what I rule. I understand the pressures of having to go from one court to another and juggling. Oftentimes use the illustration of practicing. Ms. Roberts has heard this over and over. I give the illustration, what it's like to be a practicing attorney in private practice especially is like when I was growing up, we used to watch the Ed Sullivan Show on Sunday nights, and he'd have a guy come on there who would spin plates on a stick, and he'd have about 10 or 12 sticks stuck up there, and he'd spin a plate, he'd get them all spinning, and first one would be about to wobble and fall off, and he'd run back down there, and it's running back and forth and trying to keep those plates all spinning at the same time without one falling and breaking is very similar to what it's like to practice law. So I understand you've had a rough morning. Don't take it personally. So you go right ahead and make your argument. You don't have to, you don't know, appreciate the apology, but I'm not going to worry about it.
Thank you, Your Honor. That being said, the answer to the question of whether or not the court can decide jurisdiction is, to be sure, yes, it can. You also asked me a follow-up question, which I failed to answer to any degree of competency, but I'll ask you now. I'll answer it now, if the court will let me. You asked me, what if two parties lived here in Tennessee and residency was clearly established, and then one day the husband, who was a resident of Tennessee, moved to California and he filed there. The next day, wife filed a case here. Which court had jurisdiction? Well, in that case, the answer is Tennessee. I would say.
Actually, let me interrupt you because I think I may not have made it clear.
Okay.
Now, my illustration was not intended to say which court had necessarily jurisdiction. The question is whether or not the fact that one person filed a day after moving to that state would prevent this court from being able to entertain the issue of jurisdiction. I agree with you. That's a pretty simple illustration because every state requires certain residency requirements. But
Cool.
I apologize for interrupting. Go ahead.
No, it's quite all right. So there's that question. So I think the court is abundantly aware of the argument that I'm trying to make. And I read Conley versus Conley, and I agree with the court, not for what it's 2 cents it's worth, that someone can have multiple residencies. And obviously the court will rule on that determination today, although I do think this case is distinguishable because in the Conley case, it involved two parties who lived in Florida. Husband moved here and had significant ties with Tennessee. And rather than competing complaints for divorce in separate states, it was more or less a general grievance as to Tennessee, as wife contended that the acts which gave rise to the divorce occurred in Florida, along with some other things that indicated that perhaps he was a resident of Florida as well. That being said, my arguments as to the first to file are going to be more of a question of what is the appropriate venue to hear the issues that are before the court beyond jurisdiction today. And I have gathered that the court seems to be aware of that. So I appreciate the opportunity to correct myself. After having a well-needed hour to collect myself. You know, I think the first and file doctrine and Article 4 are both kind of in accordance with the fact that perhaps these pendente liti issues, which the court will determine next, I realize, are better suited until California also rules on whether or not jurisdiction was proper, and then the two courts converse if they're in disagreement with one another. Thank you.
All right. Ms. Roberts?
Jay Regier, oh my God. I already own many handcuffs. I bring my own handcuffs to the table.
Your Honor, I think as Your Honor has indicated, people can be domiciled in more than one location at a time. They can have dual residencies. So again, it really comes down to an issue. I think probably what we're looking at is California and Tennessee having what we would define as concurrent jurisdiction, possibly. And then you get to the point of, is there one court that has the superseding authority over the other? And as counsel has said, it's more like for lack of a better way to put it, a convenient forum. What is the most convenient forum to litigate these issues? You have a situation where Tennessee is a common law property state, and we are not a no-fault properties. We are not a no-fault divorce state, and we are, our division of assets is by
Now,
common
you
law.
made a statement, I'm not sure you're correct. You
Yeah.
said that Tennessee is a common law state,
we-
common law property state.
Well, what I'm saying, number one, we are no-fault divorce. We are not a no-fault divorce state. California is a no-fault divorce state. Tennessee division of assets is based on the common law, which is an equitable division of assets. California is a community property state where it is just a 50-50 division. So you have different applications in what's going to happen, but what's undisputed, and again, my client is her basis of the argument is that her husband moved to California on a temporary basis to get a job. And he kept residency in the state of Tennessee. So he probably can be classified as a dual resident. But his intention was to remain a resident of the state of Tennessee as he registers his car here. Even though he says he's not registered to vote in his testimony, Tennessee is a motor voter state, so he technically is registered to vote in the state of Tennessee. His insurance is here. No testimony is that he disclosed to his insurance company that they had moved to the state of there. He had a driver's license, and again, his answer is when did you change your Tennessee driver's license? And his response is, I don't know, I don't know, I don't recall. My client testified. He told her. He did it in December after the filing. He changed the automobile insurance after the filing. All of those things that occurred because he was trying to make himself more of a resident of the state of California rather than the state of Tennessee. But all of that to be said is these people are property owners in the state of Tennessee. They are not property owners in the state of California. California can have personal jurisdiction over Mr. Knopfsinger. I do not think that they can have personal jurisdiction over Mrs. Knopfsinger because if she was not there to be served, she's not a resident. She hasn't established a residence there. And again, she would have had to been there for 6 months. And if you count the number of times based on the testimony that's before the court is she is 2 to 3 weeks shy of ever being a resident of the state of California. So the California court can order Mr. Knopfsinger himself, because they have personal jurisdiction over him, to do certain things as it relates to the property in Tennessee. But California has no authority over the property in the state of Tennessee. If they order Mr. Knopfsinger to sell the property or to pay the mortgage or to do anything like that, they can tell him to do that, but they don't have any in-rem jurisdiction over the property. So that's the controlling factor that I think the court needs to hang its hat on as far as jurisdiction is concerned, and superseding concurrent jurisdiction is the most convenient forum, if you would, is to do it here. Because you need jurisdiction over, in-rem jurisdiction over the property that's to be divided. And there is no property in the state of California. And so again, I think it's, as bluntly as I can put it, I do think that this is possibly a concurrent jurisdiction with California and Tennessee. And it comes to the point of whether or not, who has the superseding authority to do it. And whether or not they both, if you both have jurisdiction and we both proceed with the divorce filing and the divorce, then again, we end up having competing orders. And again, as counsel said, then we're bound on an appeal to determine what that is. But I think it rests on the fact that these people own property here in the state of Tennessee. And as for that, I think the court has jurisdiction to proceed, because not only do you have personal jurisdiction over both of the parties, you have in-rem jurisdiction over the property.
You have the last say, Mr. Walker.
Okay, so just before Mr. Walker gets the last say, let me remind everybody a little bit about what they're fighting over here. This is the beginning of what will be a long legal battle. Thank you. Make sure if you're just getting here, vote in the poll. I want to know if you want to see me choose some polls. I'm just joking. No, seriously, what's happening in this case is that he filed first in the state of California. She filed days later in the state of Tennessee. Now, the state of Tennessee is hearing this case first. I know, Adam, I'm actually hurt. I've been handling it, but I am hurt about that. Whew. Anyways, I'm moving on. Let's hear what the final arguments are here. If you missed this whole thing, we heard both husband and wife testify yesterday in our live, so you can check that out. But this is going to be the judge's response. We're going to get what his decision is very shortly.
So, respectfully, Your Honor, I do have to disagree to the statement that someone can be domiciled in two places. In fact, I think Conley specifically indicates that someone can be a dual resident, however, they can only hang their hat in one place. My client here today...
You read the case in Conley. It does state that a person can have many residences, but only one domicile. That's quoting a Supreme Court decision.
Yes.
So.
Yes, Your Honor. And I think that my client has clearly indicated, and I think it's been failed to be rebutted, that he ever had any intention of changing his domicile to be Tennessee again. I agree that there is race here, and that is probably a question of law. But whether or not, the California courts, so the crux of my argument is, sure, there is concurrent jurisdiction and there are battle of the forms. I think, pretty sure they're still teaching it in law school that the first to file is typically the one that sort of, we're not dealing with liens, but sort of perfects it, that would get the opportunity to rule on the issue. So the California court may very well indicate that Tennessee is the more convenient form, despite the fact that my client filed first. Right, that's entirely possible. But I would say the first to file doctrine and Article 4, I think it affords them that opportunity to make that determination. And I think that Tennessee courts would respect, the same cooperation and deference from the state of California as well. So, to be sure, two places can have jurisdiction. As to whether or not California has jurisdiction is a question of California law. I think it's fairly clear from the evidence presented that my client is domiciled in California. And although there is raise here, I think it might be a little bit of a stretch to say there's nothing there. We get into property as far as, funds earned working there. We didn't get into the bank accounts that are maintained. I don't believe I wasn't here for the first part of the hearing. But to say that all the property at issue is in Tennessee, I believe is not necessarily correct, to say respectfully. So for these reasons, I would ask that the court make its ruling on jurisdiction. I think it's going to do that anyway. But due to the first to file doctrine and Article 4, I think the California court should rule as well, and then the two courts should converse over what is the more convenient form. I don't know that it should be unilaterally done here today by a conclusion of law, just based upon a competing argument by one of the parties. Thank you.
Right, thank you. Over the lunch hour and a half, I guess I would say that I did do some further research in the matter, and I had cited the Conley versus Conley case, which is the basic premise that the parties can have more than one residence, but only one domicile. And then it gave a list of factors that, in the Conley case at least, were considered by the court to on the issue of what is the actual domicile of the parties. I want to address first and foremost Mr. Walker's argument about the prior pending suit and that theory, so forth. And I would cite to you the case of Vermillion versus Vermillion, which is a Tennessee Court of Appeals, cited at 892 Southwest 2nd, 829, 1994 Court of of Appeals decision for the Eastern Section. And in that, it was basically the argument of the defendant that there was a prior pending case in the state of South Carolina, and as a result of that, the same argument that Mr. Walker and his client make about this court should stop any proceedings here until after that case was concluded, was considered by the court, the trial court and the Court of Appeals. And I'm now quoting from that decision. I believe it's on page 832 that I'm reading from. The defendant's argument on the matter of subject matter jurisdiction is really an argument predicated on the doctrine of prior suit pending. He contends that this matter should not go forward in Tennessee because of the lawsuit in Texas was started, and I said South Carolina, but it was Texas. It was started first and is still pending. And then, but as the Atchley case, and they're referring to a Tennessee Supreme Court decision of Atchley versus Atchley, which is cited at 585 Southwest 2nd, 614, a Tennessee Appellate Court decision, 1978. But they're saying the Atchley case.
No, the only breakup that happened is in the divorce. I've been single forever. I was just thinking about content creation for the next month, and I thought, well, fuck. What are your best assets, Pays? And that's what led me to think that. And also, this is for you, buddy. Up there in heaven, here's some tits. I apologize, but we're rude to all religions when I can think of funny jokes or offer my tits.
Clearly indicates the concept of the, quote, race to the courthouse, end quote, is not critical to determining whether a state should exercise subject matter jurisdiction in a divorce case. And in the Ashley case, they cited with approval the following language from 24 Amjur Divorce and Separation. Quote, the pendency of an action for a divorce or separation in one state will not require abatement of an action for a divorce subsequently brought in another state. That's again quoted out of the Ashley case at page 620. Abatement of an action pending in this state because of an action pending in another state is a matter within the sound discretion of the trial court. So when I make this determination, we now know it's not a bar to this suit hearing it. And under the circumstances, then it falls to me to try to determine whether this court would be the appropriate forum, whether jurisdiction actually lies here. And I have to then refer to Tennessee Code, which sets forth the residency requirements for anyone to file a divorce complaint.
No, Ryan Hall is not single. In fact, I have breaking news. Ryan Hall is having his third child. I know the name of that child. He announced it live yesterday to the shock of his staff who did not know. Ryan Hall has 2 children already with his wife. I believe her name is Stephanie. It's always a Stephanie. Anyways, their kids' names are like Echo and Otto and Milo, the third one's gonna be. Congratulations to Ryan Hall, F in the chat for him. As we know, I have a love-hate relationship with Ryan. Obviously, still hate watching. I guess he's my Adam the Woo. Anyways. I love you guys, though. Also, thank you for your support, Cellulite Yoga Pants, for your 17 months. And secondly, I've already dated my roommate for like many years. That didn't work out. So, that one's a no. Next idea.
In the state of Tennessee. Tennessee Code 364104 sets forth the residency requirements, and subsection A states the following. A divorce may be granted for any of the causes referenced in 364101 if the acts complained of were committed while the plaintiff was a bona fide resident of the state, or this state, or if the acts complained of were committed out of this state and the...
That means if you travel out of state to cheat while you're in Tennessee, while you live in Tennessee, the court takes issue with that. NPC, thank you so much. I take no issue with you gifting a membership to Robert Sanderson. Hi, Robert. Welcome. Thank you, NPC. So just keep that in mind. That's what the difference between a no-fault state is and an at-fault state is. At-fault states want the T. They want the T. And you know what? So do we, technically. But not if it's about us. I would say that's where we draw the line.
Plaintiff resided out of the state at the time if the plaintiff or the defendant has resided in this state 6 months next prior of filing of the complaint. In other words, the residency requirement is that you reside and be a resident of the state for the 6 months preceding the filing of the complaint. And it goes on to make some other in a subsection from that. So it really boils down to whether or not the court finds that there was a residency by either the plaintiff or the defendant in this state at least 6 months prior to the filing of this complaint in this court. There's no question that the proof has established that Mr. Knopfsinger had relocated to the state of California. I do find that the evidence established that the parties were previously living, I think, in the state of Illinois and relocated in probably around 2020 to the state of Tennessee and in Dixon County. I think the evidence was that he came earlier, but she actually renovated or relocated and established a residency here in 2020. They acquired 3 parcels of real property. One was the home that they renovated and flipped and sold. The other was that the house that they were living in, and another one was a vacation or lake house property in Henry County, Tennessee. Proof established that Mr. Knopfsinger was traveling extensively for his work, and that in 2023 rather, or thereabouts, he went to California on a trial basis to live in the state of California and see how that was going to work out. They say he may say it was intended that he always going to be there, but in any event, the initial travel to California was, according to what I find, to be on a trial basis. Mrs. Knopfsinger remained in the state of Tennessee and in Dixon County, and although she remained here, she would travel to visit him, and he would come back to Tennessee to visit her as well. The important parts of why I find that Tennessee has jurisdiction is, and why I believe that Mr. Knopfsinger has failed to establish that he established his domicile in the state of California are as follows. The proof has been that he had a Tennessee driver's license. He couldn't remember when he changed the Tennessee driver's license to a California driver's license. It was in his wallet in his room that he was in. It would have been an easy matter for him to stand up, walk and get that license and come back and be able to demonstrate it to this court's satisfaction that he had had that license changed many months before this, before he filed for divorce. He didn't do that. And as a result of that, he couldn't remember when he had it changed. Mrs. Knopfsinger said he had a Tennessee driver's license up until after he filed for divorce. So I accept her testimony as being the factual basis for that. So he had a Tennessee driver's license in the state of California, and as we all know, there's a law that requires you to, in every state, to change your driver's license to the state that you're residing in if you move to that state within a certain period of time. I had to do it when I moved to Texas for law school. I had to do it again when I relocated back to Tennessee. Even though I lived in Texas, I came back home quite a bit during the 6 years I lived in Texas, but I still had the Texas driver's license until I actually moved to the state of Tennessee again, and then I got a Tennessee driver's license because the law required it. The same thing with this Mercedes-Benz that Mr. Knopfsinger drives in the state of California. His testimony is that it's registered even today with a Tennessee tag and a Tennessee registration. anyone who has a Tennessee registration on their vehicle, you open that glove box and take it out to show a police officer who pulls you over, it will show your name and it will show your residence address. If you have a different residence address than that, you're required to change your registration on your vehicle and show that properly so that if you're pulled over. The fact that Mr. Knopfsinger did not change his registration on his vehicle and continued to get a Tennessee registration for a vehicle that he purchased in California and drove in California indicates again to me that his intention was never to establish, or at that time was not to establish, his domicile in the state of California. Because if he was intending to do that, then he was violating the laws regarding the registration of that vehicle. His reason that he gave for, in his testimony, for keeping the registration on these vehicles in the state of Tennessee was for insurance purposes. Well, guess what? If you obtain insurance on a vehicle claiming that you are driving it and residing in the state of Tennessee when you actually reside in the state of California, according to his argument, that is considered to be, in my opinion, possible insurance fraud. So if I find he's a resident of the state of California, I'm basically saying he's guilty of insurance fraud, and I'm not prepared to do that because I think he intended to keep Tennessee as his domicile so that he could maintain the insurance on the vehicle properly and so forth. And again, those registrations on both his vehicle and the vehicles that are here, the other 2 or 3 vehicles that they have here in the state of Tennessee are all in the state of Tennessee. The insurance is in the state of Tennessee and so forth. The other evidence that I'm finding as the basis for finding he had not intended to change his domicile was that the federal tax returns were for 22 and 23 were filed showing the residents to be in the state of Tennessee. And this court has viewed the testimony of the parties, and I've judged their credibility as I would anyone else. And based upon my observations of their credibility and their testimony, I find that Mrs. Knopfsinger was at all times intending to maintain her residence and domicile in the state of Tennessee, and that Mr. Knopfsinger had failed to demonstrate by competent evidence that he intended to change his domicile to the state of California prior to May of 2024. And in May of 2024, when they loaded up and they moved back, perhaps was his intent to change his domicile to the state of California. And if that is the case, he's failed to establish domicile in the state of California for the requisite period of 6 months prior to filing this complaint. It would show that he had filed the complaint some 5 months and some odd weeks, but less than 6 months prior to the filing of that complaint. I find that Mrs. Knopfsinger never intended to change her residence, or domicile rather, to the state of California. That her testimony, and I credit that, was that she intended to go to California to try to salvage her marriage, and that she would stay there, but that the properties that they maintained here were still in Tennessee. They never listed their lake house, according to what I'm understanding, and the house that was listed, that was here, was listed for sale but never sold, and she returned. Whatever the issues were, that she returned to the state of Tennessee in November the 10th by his testimony. November the 10th is when she left and intending to return to the state of Tennessee and resume her domicile here. For all of those reasons, and I've stated all of those reasons on the record so that it will be clear to the California court, and I intend to put an order down that would do that, that I believe that domicile of Mrs. Knopfsinger was clearly established to be the state of Tennessee, and that he failed to establish domicile in the state of California for the requisite period of 6 months. But beyond that, as the court stated in the Vermillion case that I've cited to you, there are factors that the court has to determine, in looking at which state has the better jurisdiction, which state is the more appropriate venue for this. And one of the factors that in the Vermillion court stated was that both, in that case, both the parties were living in Tennessee at the time that she filed her action. But the property to be divided by the court was in Tennessee in the Vermillion case. And that was a factor that the court in Vermillion held was a basis for this court for jurisdiction for the state of Tennessee. In this case, the property that the parties own, the real property, which is the most significant aspect, at least is what I've been aware of from the testimony, was in the state of Tennessee. It's located here. As was pointed out, this court has in-rem jurisdiction and personal jurisdiction over the parties. And as a result of that, I'm of the opinion that this is the appropriate venue and the appropriate case, court to have jurisdiction over these issues. I say all those records, all of those on the record for the parties' benefit, as well as I will issue a written order pretty quickly about that. Now, having said that, it is my opinion that equity and the benefit of, to avoid any sort of, in the interest of judicial economy, that we need to reset your substantive motions until after this hearing in the court in California. What day is that hearing supposed to take place? The 28th of May? All right. Then, with the 28th of May being the date that that hearing is taking place, I can give you the 30th of May as a hearing date in this matter.
Yes, sir.
Mr. Walker, is that date available?
30th of May, ladies and gentlemen. Imagine. Oh, where
That
will...
is not a regular chancery day, but I'm giving it. That way we'll see one way or the other what the California court's doing. And
Be in Montgomery at 9 a.m.
Montgomery County.
Montgomery County, yes, Your Honor. Sorry, Clarksville. If the court has an afternoon docket, that would certainly work.
I'm sorry, repeat that. You got to be in Montgomery County before we, I was looking at my calendar. What's the last thing?
Yes, Your Honor. I've got to be at Montgomery County for Pedente Lady hearing at 9 a.m. But that's a quick drop down here if you wanted to do afternoon docket.
Well, I don't have a docket on that day. I'm giving you this day specially, so.
Well, if we could set it after lunchtime, I should certainly be able to make that.
1:30 on a Friday afternoon is, I mean, if depending on what they rule, we have to determine whether or not we're going to go forward with these motions. Ms. Roberts, you also have the Bates versus Bates case
Yes, Your Honor.
on the 16th of June.
Okay, so I want to point something out here. Now, listen, lots of other channels would have cut this by now and been like, sorry, they're just scheduling. But I find it really interesting, the really intricacies of court. Okay, so here's the thing to keep in mind here. And the lady lawyer won in this hearing. Congratulations. I don't always agree with her style, but I don't watch this court all the time, but she sort of rubbed me the wrong way. And I like to be rubbed the wrong way, so strange that I didn't like it. But, she proceeds here to make a statement which I think is a bit inappropriate, because she sort of updates the judge on this other case, and it seems ex parte. And I know it'll be like, oh, small town court, this is the way that we do it. But it's just, it felt weird to me when I first heard it. I was like, what? Hold on now. And secondly, thank you, Brian, for your compliment. I don't need a jet. Why are we getting an idea that I'm high maintenance? I'm low maintenance. High attention, low maintenance kind of girl.
The 16th and the 23rd are the two dates you said. We are close to resolving the property issues, so that will just leave us with the custody scenario. So I can't definitively say we've got that done, but we are very close in getting that done. I actually have a meeting with my client on Monday to hash out the final aspects of the property division.
Well, the property division is on the 23rd, according to what I have.
That's what I was saying is you have 2 days. And so it was the property that we were going to do the custody scenario first and then the property division after
You
that.
want to, your motions, do you want to set them on the 23rd?
My client is scheduled something to be out of town on the 23rd. Can we possibly, again, I know a 1:30 on a Friday afternoon, could we possibly have just a status hearing, even if we, on that day to see?
Yeah, we'll do it.
Because
1:30 on the 30th of May.
I want to make sure, because again, I don't know that the California court will rule that day. I'm not familiar with the practices there. I don't know if they'll take it under advisement. So again, I think if we can just do a status conference on that day, and then we can pick, then that way I'll know whether or not that Bates case is resolved, and then we can put it, and then we won't be double booking on the 23rd if it doesn't.
Well, is there any reason it has to be an in-person?
No, sir, I
If
don't,
you
that's what I'm
need
saying is,
to do it by Zoom, we can do your hearing, do the status. We're doing a status so that we try to find out what California court's done and then see where we are. Then we can do that on the 30th at 1:30, even by Zoom.
right, I think that would be fine, and like I said, if we get a ruling and we know, counsel and I talk with their respective counsels in California on the 28th, and they say, this is what's happened, then we can just call the clerk and get a date and advise Your Honor that, hey, California's not going to hear it. If California is going to hear it, then we can discuss it at that point in time on what we need to do. But I think that would be appropriate, just to do the status.
One thing that parties need to think about, and clearly you can, if I rule that we have jurisdiction and California rules they have jurisdiction, then both sides are going to be going up on the appellate
On an
ladder.
interlocutory.
And that's going to be costing both sides a considerable amount of money. So it may, I always like to quote this. You're too young to remember this, but there was a movie that had a great impact on my life when I was in high school called Butch Cassidy and the Sundance Kid. And there was a line from that movie that I always quote: when they are followed by an all-star posse and they can't lose them, and then they figure out that every famous lawman in the West is in this posse, they say, he must be spending a fortune to make us stop robbing them. And Butch turns to Sundance and says, if they would just pay me the money they're paying to stop me from robbing them, I'd stop robbing them. And I always think about that when parties are litigating cases all the way up, and the principle of the matter is a great thing, but at some point you have to determine, is it more beneficial to you to try to resolve this case in some sort of informal and less expensive way than it is to litigate the issue of jurisdiction on a principles basis. But it is a decision that we'll reach when we get to it. I will put a written order down so that can be shared with the California court for whatever benefit they want to give it. They're not under any obligation to follow my ruling, as we all know, but we'll let them at least know the factual basis for my ruling.
Thank you, Your Honor.
That concludes this hearing. Therefore, we will stand adjourned.
Thank you, Your Honor.
Thank you.
Everyone stand up. Oh, shit. Amazing. So that means that we're going to hear more about this case, I believe. Okay, we are pretty much done here. I did set this up to redirect over to Colin. I hear that him and Team Skeptic are doing something fun tonight. So I've redirected you over there. Make sure to say hello. Yeah, let's hope for a chase. Maybe if I still look so good tonight, I'll be a West Coast correspondent if we get a good chase. So let's pray for a Monday chase, and I will send you guys over. We have court tomorrow to watch. Oh, sorry. Let's finish up with the poll, Mikey, the poll. Hold on, please. I don't know how to end it from here. I wish I wasn't covered with fear. No, I'm just kidding. I'm not scared of shit. If you're scared, call the police. And the poll. Still, I am tragically obligated to advise that 0% of the people want to date me. That is a blow to my ego today that I did not need, guys. Thank you for that. I really appreciate that. Not even one of you. Not even one. Wow. Okay. Great. No, I'm just sort of kidding. I mean, it hurts, but I'm kidding. You're lucky YouTube won't tell us who fucking voted. All right? No. I'm just kidding. I'm kidding. I understand. The reality is the people that voted in that poll probably know me the best. They're like, no, bitch, we know you. We like to hang out with you, but you were crazy. I get it. You get it. We all get it. This is why we're friends. I love you guys so much. Yeah, it's not me, it's the poll. I swear to God, this never happens. This never happens to my poll. Do me a favor, remember that I love you and I'm proud of you, and I will see you in the next video. Okay, bye.
Ways down